a stretch break, members of the jury.
All rise.
We'll get you back here in a few minutes.
You may be seated.
Everyone have a seat. State's rest. Defense, anything we need to go over?
Yes, Your Honor, Mr. Schultzman, how are you?
Okay, go ahead, Mr. Shaw.
Your Honor, at this time we make an enforcement motion to dismiss count one. Sorry, ask for a judgment of acquittal on count one.
JOA, okay. State, brief argument.
Your Honor, the state has put on a prima facie case. It's given enough to make this an issue for the jury to determine whether or not the acts of Tracey Nix were simple negligence or culpable negligence based upon the surrounding circumstances. Culpable negligence cannot be determined without a jury looking at those circumstances that surrounded the negligence and determining if they're wanton and reckless. And I believe the state has put out enough evidence for the jury to make that decision.
All right, based upon the state's presenting a prima facie case, this case goes to the jury. JOA is denied.
Your Honor,
Go ahead.
for the record, I'd like to make an argument, and I'd also like to present just a copy of the order from the Florida Second Circuit Court. It's not binding, obviously, but it is persuasive.
Is this for count two?
This is for count one,
Okay.
culpable negligence.
All right, go ahead and all right. Go ahead.
Your Honor, the definition of culpable negligence requires someone consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The evidence presented yesterday and today by the state in its case does not demonstrate any conscious action by Ms. Nix. In fact, all of the conscious actions taken by Ms. Nix that day were for the benefit of her family. She was doing a favor for her daughter. If you watched her in the video, you saw her put the child in the car seat. What would have been reckless would for her not to put the child in the car seat, put her in the backseat of the car and just drove around like that. All of her conscious actions, and you heard from witness testimony from the three friends that she had lunch with, that she was behaving normally, that she was a loving, caring, doting grandmother, that she was happy, that the child was happy. All of that demonstrates that she was acting in an appropriate manner. The state didn't show anything that was an aggravating factor. There was no evidence of substance abuse. There was no evidence of prior abuse. There wasn't any evidence presented of her repeatedly leaving the child in the car before. So, Your Honor, we argue that there's no evidence of her doing a conscious act or doing a reckless act that would have put the child in danger. And without one of those acts, or without some aggravating factor, the state cannot reach the level of culpable negligence.
Okay, is this case appeal still pending?
This case here is actually, this case was an order granting a motion to dismiss, and I don't believe the state tried to appeal the motion to dismiss. I put this into the record specifically because it does probably the best job I have seen analyzing all of the case law around culpable negligence, particularly when it comes to a child being left in the car. And one of the things that I noticed, and I thought it was strikingly similar to this case, the court ultimately concluded that the act there was, it was a single, unaggravated, and inadvertent act of negligence despite the tragic consequence. The admitted facts are insufficient to support the offense of manslaughter by culpable negligence. And essentially in this case, it was a mother who had taken her, she had two children, each went to separate schools. She took one child to school and she forgot to take the other one and drop it off to daycare. She went to work and she went about her day. She even received a call about the child from her partner, I guess it was her former partner, and they discussed the child. And it wasn't until she actually went out to lunch to go leave that she realized that the child was in the car, and the child unfortunately had passed away. And the court in that case found that essentially the act of negligence of leaving a child in a car is one of simple negligence. And the court also found that because of the way that memory works, that the amount of time isn't really an issue. when you forget something, you forget something. You don't, there's no way you can control when you're going to remember. Now, maybe there's something that cues you to remember that, but, you know, people forget things all the time. I mean, I might drive down to my driveway with the intent to go get my garbage can and then drive all the way to work and realize I didn't do it. But then I might not realize that until I get home and I see it in the driveway.
Okay, thank you. Anything further from the state?
Your Honor, I believe this case, first off, this is a circuit court case, and it is a motion to dismiss, and it's a trial case. I would say this case is distinguishable because we have, Tracey Nix was the sole caretaker of a sole child that she spent all day with, or excuse me, all lunch with. And the facts as far as what she did in providing all that care and all that time with her at Beefville Brady's and getting in that vehicle, going home, and just thinking about other things other than that child, Your Honor, I believe it's distinguishable from this matter because in this case that the defense has cited, once again, this circuit court case deals with a person taking care of two children being distracted by one and the other. She had no other distractions. Her only responsibility was to this child. Only responsibility. And she provided that and then stopped. And I think that's different here, along with the other factors that are present there. It's not just those two things, but I'm just pointing out that which makes it distinguishable from the case that the defense is trying to present to the court. And once again, this is a motion to dismiss, not a trial case in which the question was whether or not there's a prima facie case.
All right, based upon the evidence that I've seen, the evidence, the 64, 65 items, and the testimony, the state's presented a prima facie case, JOA is denied. Same rule. Second, the argument, if any, from the defense.
Your Honor, on count two, we will reserve our objection to the jury instruction on count two. We're not making an argument for a motion for judgment of acquittal on count two at this time.
All right, so there's no judgment of acquittal, so there's no reason for me to rule on it. All right, defense, are you ready to present your case?
Yes, Your Honor.
All right, jury.
Yes, Your Honor. Ready, Judge?
Yes, bring it.
All rise.
All right, members of the jury have a seat. Defense, please present your case.
They call me Nix, Your Honor.
Mr. Nix.
All right, Mr. Nix, just stand in the circle. Swear you in, sir.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Can you step this way, sir?
Sir, have a seat.
Step around.